We're taking you now live to Michigan, where Ethan Crumbley, the shooter in the Oxford high school shooting, is about to be sentenced. You may recall that shooting took place in 2021 at Michigan's Oxford High School.
Let's go ahead and listen into the judge here in the case.
Prior to this offense, he started to formulate this plan and knew and asked for the weapon that he could cause the most harm with. As counsel is aware, the goals of sentencing do not only involve rehabilitation, but also involve deterrence and punishment. Deterrence is two parts. It's private deterrence for the defendant in hopes that they would never commit an act like this again. But then there's also public deterrence, where the public sees the punishment that the individual has received in hopes that the public will never do anything like this in the future. The court has read the report from Guidepost Solutions. It was very lengthy. Respectfully, the court does not find this report to be mitigating in this case. The report simply points the finger at Oxford Public Schools. While the court agrees that more possibly could have been done, that issue is not properly before this court. We are here for sentencing based upon the defendant's actions, not the alleged shortcomings of others. As the defendant pointed out himself, he took responsibility. And he himself is not asking this court for a term of years. The court cannot underscore defendant's extensive planning and execution in this case enough. He practiced shooting at a gun range. He practiced racking and unracking the gun. And on November 30th, 2021, he could have chosen not to conduct the school shooting. When his parents were called to the school on that morning for his drawings, he could have said something then. He had a gun in his backpack at that time. When the school counselor advised the parents to please get him help within the next 48 hours, he could have stopped then and simply accepted the help that was going to be offered for him. Because according to the reports, his mother said that she'd get him the help. He could have changed his mind. Unfortunately, after shooting the first person, Phoebe Arthur, he could have changed his mind at that point. But he didn't. He continued to walk through the school, picking and choosing who was going to die. As the defendant said in his own words, this is nobody's fault but his own. He stated this afternoon that with help, that probably would not have stopped him. That is absolutely concerning to this court. The court apologizes to the victim for the bluntness, but defendant shot and killed Justin Schilling at point-blank range after having him get down on his knees in front of another student. He shot Hannah, who was already shot once before. He walked up to her to finish the job by shooting her again. That is an execution. That is torture. He shot most people multiple times. And as he wrote, he did this for notoriety. And he wanted to go down in history as the biggest school shooter in Michigan history. The court cannot ignore the deep trauma defendant caused to the state of Michigan, but in particular the Oxford community. The court simply cannot ignore that. The court notes that teachers and students returned to Oxford High School after this tragic event. The court cannot even fathom or imagine walking through the halls of that school knowing that your fellow student, your friend, your classmate was killed in a restroom or in the hallway. Most, if not all, of the letters that I read advised the court that there are a significant number of people in Oxford that now have PTSD, that now have survivor's guilt, and deep depression that arose from this incident. Defendant's actions clearly created a new normal for all of the individuals involved, and all of those indirectly impacted as well. Unfortunately, this is what the defendant wanted, as he wrote in his journal. He wanted to see the impact of his crime, which is why he did not take his own life. Again, this goes back to the defendant's extensive planning. He chose not to die on that day because he wanted the notoriety. The terror that he caused in the state of Michigan and in Oxford is a true act of terrorism. Respectfully, defendant is the rare juvenile before this court. The court, having read the PSI and being fully familiar, but before I get that, I will also note that counsel brought up an issue of making bombs for Hitler. The court, that does not change the court's opinion about the defendant's obsession with violence. I thank Ms. Hott for bringing that to my attention, but it still does not change the court's opinion about him being obsessed with violence, because his obsession was also outlined in the websites that he visited. His obsession was also outlined in his extensive drawings of violence. And his obsession continued, as I noted in the court's opinion in order, even while he was in the Oakland County Jail. With that, the court, having read the PSI and being fully familiar with the defendant and the underlying facts of this case, believes that it is in the best interest of justice as well as proportionate to the needs of this case to sentence defendant as follows. As it relates to docket 2022-279-506-FC, count 1, terrorism causing death. Sentence of the court is that defendant shall serve life without the possibility of parole, credit for 8 days served. Counts 2 through 5, homicide, first degree, premeditated murder, juvenile defendant. Sentence of the court is that defendant shall serve the rest of his life without the possibility of parole with the Michigan Department of Corrections, credit for 8 days served. On counts 6 through 12, assault with intent to murder. On each of the counts, defendant is sentenced to 18 years and 9 months to 80 years with the Michigan Department of Corrections, credit for 8 days served. On counts 13 through 24, those being felony firearm, defendant is sentenced to 2 years with the Michigan Department of Corrections on each of those counts with credit for 730 days served. Counts 1 through 12 are concurrent to each other, and counts 13 through 24 are concurrent to each other. Count 1 is consecutive to count 13, count 2 is consecutive to count 14, count 3 is consecutive to count 15, count 4 is consecutive to count 16, count 5 is consecutive to count 17, count 6 is consecutive to count 18, count 7 is consecutive to count 19, count 8 is consecutive to count 20, count 9 is consecutive to count 21, count 10 is consecutive to count 22, count 11 is consecutive to 23, and count 12 is consecutive to count 24. All of those consecutive counts are by reason of the felony firearm statute. Is there a challenge to restitution here?
There is not, Your Honor.
Thank you. Restitution will be set in the amount of $20,781. State costs will be set in the amount of $1,632. You are not to have any contact with Oxford High School or enter Oxford High School. You're not to have any contact whatsoever with the families of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling. Also, you are not to have any contact with the following victims or their families, that being Phoebe Arthur, John Osito, Molly Darnell, Riley France, Elijah Mueller, Kylie Osage, Aiden Watson, and Keegan Gregory. And I will note that restitution is payable to the Crime Victims' Right Compensation Program. With that, Michigan Department of Corrections, did I miss anything?
Your Honor, may I ask the court to order 130 crime victims fee, $60 DNA cost, and DNA testing?
Thank you. DNA cost is $60, crime victims' right fee at $130. Did I miss anything else?
DNA testing, Your Honor.
DNA testing is hereby ordered. Thank you. With that, Mr. Crumbly, you are entitled to file an application for leave to appeal. If you are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal. The request for a lawyer must be filed within 42 days after sentencing. Your attorney is going to be handing you an appellate rights form, sir. Do you acknowledge receipt of the appellate rights form?
Your Honor, I have tendered that to my client. He has signed it, and I will tender it to the court.
Thank you very much. With that, counsel, anything else for the record?
Not from people, thank you.
Nothing from defense. Thank you very much, Ryan.
Thank you very much. With that, deputies, you may take Mr. Crumbly. To those in the gallery, please be seated until he is exited.
We watched that here live. Oakland County Circuit Judge Kwame Rowe sentencing Oxford High School mass shooter Ethan Crumbley to life in prison without the possibility of parole for murder, terrorism, and the deaths of 4 of his fellow students back in 2021.
We heard the judge in the case, Judge Rowe, talk about the profound impact that this crime had on the community of Oxford, on Michigan as a whole. But he described this in making his decision as something that was necessary not just for private deterrence, we heard the judge say, but also for public deterrence in the hopes that nothing like this would happen ever again in the future. And the judge, in going through and recounting the events back in November of 2021, when Ethan Crumbley, who was then 15 years old, basically carried out this mass shooting, the judge said that was an execution in describing what took place, that was torture, that he shot people multiple times, and that he wrote later, he wrote that this was done for notoriety. The judge also said the court cannot ignore the deep trauma, he said, to the Oxford community, and the court cannot even fathom or imagine walking through the halls of that high school in Oxford, Michigan, knowing that your fellow students, that your friends died, were killed there in the hallway. So this is coming on the heels of what had been a really emotional day of victim impact testimony.
And right before the judge handed down his sentence, we actually heard from the shooter himself, Ethan Crumbley. Among the remarks that he gave, he said, "I'm a really bad person." He expressed accountability and remorse for his actions, but nonetheless, and as well as hope and optimism that perhaps he could be rehabilitated, but really not providing any sort of excuse for those horrific events. And I do think that it is worth pausing to remember those 4 students that were killed 2 years ago, 2 years and a month ago, Madison Baldwin, Tate Meyer, Justin Schilling, and Hannah St. Juliana, who is herself just 14 years old. The others had a couple more years, but gosh, those young lives so full of the possibility of the future. We will play in a little bit some of those impact statements that we heard.
Yeah, let's turn to CBS News legal contributor Jessica Levinson, who is joining us now. Jessica, you know, it was interesting to hear the judge leading up to expressing his decision. There was a question of whether or not there may have been room for rehabilitation in the court's mind. Clearly, that did not appear to be the case.
I think that's exactly right. And earlier rulings indicate that that is where the judge was going in this case, that we know what would have happened in this case if he was over 18 when he committed these crimes, when he committed these mass murders. But there was some question as to whether or not he would not get life in prison because of his age. As you mentioned, and I heard your discussion right before we went live, the judge thought that there was no chance of rehabilitation. And that means that legally, there really isn't any reason to give a reduced sentence. Legally speaking, if you don't think somebody can be rehabilitated, if the typical sentence, if you're a little older, would be life in prison, then that's what you would see. And that is, in fact, what we saw today.
The judge even made the point that Crumbley himself, in giving his response to all those victim impact statements, said that he wasn't asking for a reduction in the sentence, that he seemed to take on the responsibility of the life without the possibility of parole. I want, as we're mentioning these victim impact statements, let's go ahead and play those for our audience, and then I'll ask you about it on the other side.
And they made sure I saw her from a side that was more acceptable for a grieving mother. That was not my daughter. Madison was far from lifeless.
Now I just have to wonder, what would it have been like? My future kids can't meet their uncle. My parents can't watch one of their sons grow up. I won't get to have Tate as groomsman.
We wear the pain like a heavy coat. Constant reminders every day. Every hour is the darkest time of the day.
Every hour, the darkest time of the day. Jessica, when we hear those impact statements, obviously we all feel a great deal of emotion about that. How does that factor into the judge and handing down that decision?
I think it's hugely consequential. Now, it's not the only thing that a judge will look at, but a judge is and should be a human who is impacted by these statements like anybody else. And that's why we allow victims and their families to provide these statements. It's one, to give them their moment in court, which is often very important, even in cases that are less horrific than this one. But it's also to allow the person who's making the decision about the sentence to hear all of the information that he or she can get. And in weighing, are there aggravating factors? Are there mitigating factors? One of the big issues here, of course, is the victim impact statement. I heard your conversation again before we got on, and I think it's exactly right that this judge is listening to those statements, which are so difficult to listen to, and is thinking about not just this case, but other cases. We know that there are different reasons for a sentence. One can be punishment, another can be deterrence, and the judge is looking not just at this particular person, but is also, because of what we deal with in this country on a daily basis, looking to have a deterrent effect.
On that, Jessica, it doesn't seem like there is a deterrent effect. I understand the desire to have one, but these school shootings become more common. And in this case, the judge even said that Crumbley decided not to kill himself because he wanted to see the outcome of this. He wanted, it sounded like, this to happen. So in what way does that actually provide any sort of deterrence?
So honestly, I don't know that it will. I know that that was the intent. And I think the intent is not just looking at what did he want. He didn't want to die. He wanted to see this case play out. But what the judge is trying to do is send a message to somebody else who might not want the same outcome, who is saying these are the most serious cases. You will have no leniency. Now, again, deterrence, there is a huge body of academic literature on what actually does lead to deterrence. But what the judge is trying to say here is there's nothing that I'm going to do to bring the sentence down. Anyone who might be considering engaging in this behavior, know that the full weight of the law will come down on you.
Jessica, stay with us. We want to bring in now CBS News associate producer Kyla Peeples. She was there in the courtroom. She joins us now on the phone. Kyla, you were listening to those impact statements. You were listening to Ethan's comments. Tell us what was the mood like in the courtroom?
Well, from the very beginning, it was very tense, very solemn. All of the parents and family members and victims were all sitting together in a packed courtroom, and then Ethan came in, or the shooter came in, and it was very, very tense. Once the impact statements began, the emotions really just started bubbling over one by one. And then when Ethan spoke, you could tell definitely that the families were tired. They were ready to hear an answer of what was going to happen. This was the first time that we have ever heard anything come from Ethan or the shooter. And I think what happened was they were really taken aback almost by what he said, because he did say that he wants the families to get what they want, and they want him to stay in jail all of his life.
Kyla, I wonder if you were able to see the reaction specifically from the family members who were gathered there after everything that they have been through to get to this moment. I can't even begin to imagine what must have been going through their minds, what must be in their hearts. Were you able to see them from your perspective in the courtroom as the judge read his decision?
Yes, I could see them. And then you saw a multitude of reactions. Some were relieved, some looked up to the sky, some were still crying. A couple of the people had small smiles on their faces, kind of like a yes, a justice has been done. It was just a gamut of reactions because I think so many people are at so many different stages of where they with grief and where they are with how this is going to end, that there were different types of reactions as expected, I think.
Yeah. It's interesting because previously Ethan in court was described as being really emotionless, and in what we saw today, his head bowed. There appeared to be a moment of remorse, even him saying nobody else is to blame for this. Kyla, thank you. Jessica, I want to go back to you because Ethan's parents, Ethan Crumbley's parents, are set to go on trial next month. What should we expect from that?
So this is one of the areas of the law which sadly I think is going to become more common, where we ask if the parents and or the guardians, adults in charge of minors who engage in this type of behavior, if we can draw a line to legal liability. So we're going to be looking for fairly obvious things, to be honest. We're going to be looking for, were there warning signs that they should have been aware of? Did they help facilitate? And I know that not everybody is read into exactly what that trial will include, but essentially we're asking, can we draw a line between what Ethan did and what his parents failed to do? And of course, what his parents failed to do is to stop this from happening. And so in cases like this, you ask about access to weapons, you ask about mental illness, red flags, all of those things. It's not just going to be this trial, it's going to be other trials in the future. We're going to see this state by state continue to play out.
Yeah, and in that, this is going to be a very interesting case for that future question about trying to decrease the preponderance of these types of mass shootings, trying to move beyond just deterrence in that traditional sense to people who really do not seem to care about that. All right, Jessica Levinson, Kyla Peeples, thank you.